Elon Musk, the king of litigation, just sued Colorado over its AI law, and this may become one of the most important legal fights for AI founders in the United States. And if you are building with AI, using AI, selling AI, or integrating AI into your business, this is a case you should be watching because this is not just about Colorado. This is about a much bigger question. Can individual states start creating their own AI compliance rules before the federal government creates one national framework? And if they can, what happens to startups that operate across the entire country? Quick note before we get into it. My name is Lisette Eusebio. I am an attorney and tech founder, and this is my digital twin. I use it so I can move faster while I'm building, so we can stay informed on legal updates affecting founders' compliance. So let's get into what is happening. Colorado passed Senate Bill 24205, also known as the Colorado Anti-Discrimination in AI Law. The purpose of the law is to protect consumers from algorithmic discrimination when high-risk AI systems are used in consequential decisions. There is a lot to unpack there, so let's break this down. Colorado is trying to regulate AI systems that may affect major areas of a person's life, like employment, housing, education, financial services, insurance, legal services, essential government services, and similar decisions. So we are not talking about an AI tool that helps you write a birthday caption. We are talking about AI systems that can influence whether someone gets a job, gets a loan, housing, access to services, or gets treated differently in a legally significant way. That is why Colorado is calling these high-risk AI systems. And under the law, both developers and deployers have obligations. A developer is the company that builds or substantially modifies the AI system, and a deployer is the company that uses the AI system. So if a startup builds an AI hiring tool, that startup may be the developer. If an employer uses that tool to screen applicants, the employer may be the deployer. And Colorado's law tries to put obligations on both sides. For developers, the law requires reasonable care to protect consumers from known or reasonably foreseeable risks of algorithmic discrimination. It also requires certain disclosures and documentation, including information that helps deployers understand how the AI system works, how it should be used, known limitations, risks, mitigation steps, and information needed for impact assessments. For deployers, the obligations can include risk management policies, impact assessments, annual reviews, consumer notices, opportunities to correct incorrect personal data, and opportunities to appeal certain adverse decisions through human review where technically feasible. So from Colorado's perspective, this is consumer protection. The state is saying if AI systems are going to affect people's jobs, housing, money, education, insurance, or legal services, then companies should not be able to hide behind a black box. They should have documentation and safeguards, and they should have notice and some sort of accountability. That is the state's consumer protection theory. But XAI is challenging the law. XAI, Elon Musk's AI company, sued Colorado in federal court to stop enforcement of the law. And according to current reporting, XAI is arguing that the Colorado law violates the First Amendment. The basic argument is that the law restricts how AI developers design their systems and compels speech on politically and socially contested issues. In plain English, XAI is saying Colorado is not just regulating conduct. They are regulating companies' right to express. It is allegedly telling AI companies what kinds of outputs they must prevent, what values they must build into the system, and what they must say or disclose. That is where the First Amendment argument comes in. Then the Department of Justice stepped in, and this is where the case becomes even bigger. The DOJ did not just sit on the sidelines. The federal government moved to intervene in the case and sided against Colorado's law. The DOJ's argument is focused heavily on the 14th Amendment's Equal Protection Clause. The DOJ says Colorado's law requires AI companies to prevent unintentional disparate impact based on protected characteristics, while also carving out certain uses of AI that are designed to increase diversity or redress historical discrimination. So the DOJ's position is that Colorado's law is unconstitutional because, in its view, it pushes AI companies toward race conscious or diversity based outcomes while punishing other differential impacts. That is a very politically loaded argument. But legally, the key point is this: we now have a private AI company and the federal government both challenging a state AI law. And that turns this from one company fighting one law into a major test case over who gets to regulate AI. Is it the states? Is it the federal government? Can Colorado create its own AI compliance regime? Can other states follow? And what happens when those state laws start to conflict? That is the part founders need to pay attention to, because software companies do not usually operate in one city, one county, or one state. Most AI startups are building products that can be used nationally or globally. So if Colorado creates one set of AI rules, California creates another, New York creates another, Illinois creates another, and Texas creates another, startups may suddenly have to comply with a patchwork of state AI laws. And that is where this becomes a business problem, not just a legal theory, because compliance is expensive, documentation is expensive, impact assessments and risk management programs are expensive. So our human review workflows, consumer notice systems are, and auditing systems. And the larger the company, the easier it is to absorb that cost. Big companies can hire legal teams, compliance teams, policy teams, privacy teams, and outside counsel. But small startups do not have that luxury. So a patchwork of state AI laws can become a tax on innovation. It can slow down small builders. It can make companies afraid to ship. It can push startups to build only for the strictest state standard, or worse, it can push founders to avoid certain states altogether. But the other side of the argument matters too. Consumers need protection. AI systems are already being used in ways that affect people's lives: hiring, housing, credit, insurance, healthcare, public services. If an AI system discriminates, produces biased outputs, or creates unfair outcomes, people need some form of recourse. So Colorado's position is not irrational. The state is trying to say if AI is going to affect consequential decisions, companies should have basic obligations. They should know how their systems work. They should monitor risks. They should notify people. They should allow some correction or appeal. They should not simply say the AI did it and walk away. That is a real public policy concern. So this case sits at the intersection of several major issues: innovation versus regulation, state power versus federal uniformity, consumer protection versus compliance burden, anti-discrimination rules versus constitutional limits, and AI safety versus the race to lead in artificial intelligence. That last point matters because the United States is competing globally in AI. If regulation becomes too fragmented, too expensive, or too early, companies may argue that it slows innovation and weakens the country's ability to compete. But if regulation comes too late, consumers may be harmed before the legal system catches up. That is the real tension and why this case matters so much. And as I've stated previously, a proactive approach is better than a reactive one. For founders, the practical takeaway is simple. You do not need to panic, but you do need to start paying attention to where your AI product sits. Ask yourself, is my AI system just generating low-risk content, or is it influencing decisions that affect someone's job, housing, money, education, insurance, legal rights, health, or access to services? Am I the developer? Am I the deployer? Am I both? Do I know what data the system uses? Do I have documentation? Do I have notices? Do I have human review? Do I have a way to explain or audit outcomes? Because even if Colorado's law gets blocked, the issue is not going away. Other states are watching, the federal government is watching, courts are watching, and plaintiffs' lawyers are definitely watching. The question is not whether AI will be regulated, it will be. The question is whether regulation comes from states, the federal government, courts, agencies, or all of them at once. And for builders, that uncertainty is the problem. Because if you are building an AI product today, you are building in the middle of a legal system that is still being written around you. That does not mean you stop building. It means you build with your eyes open. You document more than you think you need to. You avoid making claims you cannot support. You understand the use case. You understand the risk category. And if your AI system touches consequential decisions, you do not treat compliance like something you can figure out later, because later, maybe when the lawsuit arrives. So the fight between XAI, Colorado, and now the Department of Justice is not just political theater. It may become one of the early tests of how AI regulation will work in the United States. And founders should be paying attention now because the legal fight is no longer theoretical. It is already here. If you find this content useful, please support the channel by subscribing and sharing with others who many find this information useful. As always, I'll continue to bring you the latest on AI and law compliance as they develop.